Welcome back, everyone. So, just when you thought the case with Lori Vallow in the state of Idaho couldn't get any crazier, well, then this past week came up and we found out that it can get crazier. And I really wonder at this point if her attorney is even competent to go forth to actually defend her in a meaningful manner, because the state should probably look into it, into Mark Means, and decide if he is competent to actually go forth, because immediately after she's found guilty, she's going to file. And you can bet your last dollar she's going to file and say that she got ineffective counsel. Now let's take a recap and look at some of the crazy things that Mr. Means has done so far in his defense of Lori Vallow before we even got to this past week and his crazy request this week alone. So it needs to be noted that Mark Means, as an attorney in his entire professional career, has never defended someone all the way through trial in a criminal felony case. He's never taken a felony case from beginning all the way through the end through a trial. He has no experience as a trial lawyer at all in a criminal defense situation. How he's going to be able to defend Lori Vallow at all beyond here, I don't know. And there might be some foreshadowing here from the crazy requests and wrong requests that he has filed so far. So far, he has filed motions that have just been, they've been laughable by even, first-year law students. And he's filed a lot of foolish motions, asking for the wrong remedy in the legal situation. Example of this is that he filed and wanted a bail reduction from $1 million to $10,000 for his client Lori Vallow on the grounds that they may have recorded a phone call between client and attorney. And if that ever would have happened, the remedy in that situation is that phone call that would have been recorded couldn't be used in the court case at all, nor any evidence that they actually learned from that phone call could not be used in the actual case at all. That would be the proper remedy in that situation, not a reduction in bail from $1 million to $10,000 like Mr. Means had filed a request with the court to have happened. Then he went out and filed a series of motions to have evidence discarded from the case, thrown out, not be ruled upon, and not be used as evidence. He wanted that evidence thrown out before it was even listed as evidentiary, before either the DA or he was able to even have it and say, look, that we can have this in the case. It never been ruled on. He filed to have it thrown out. Get that again. Thrown out before they ever used it, before it even made the DA's list of evidence or the defense's list of evidence. And we can't forget the crazy request to have Mr. Wood removed from the prosecution of Lori Vallow and Chad Daybell because he had a conversation off the record on how an interview was going to be structured. And he wanted it thrown out for that grounds. He said that it was witness tampering, and that it was coercion of the witness. And the part that he objected to was, okay, we're going to start the recording at this point, we're going to stop at this point, where I'm going to ask you these questions, basically walking someone through an actual interview while it was going to be recorded. But that was thrown out, all of it. No censure, nothing at all. He was trying to take away, not only, get him kicked off the case, but if it went through, it went all the way up to the state bar And it could have, meant that Mr. Wood would have lost his license to practice law in the state of Idaho, and could have gotten him disbarred if he had been found guilty of actual witness tampering or coercion of a witness. But Mr. Means filed these motions anyways, and it was such a serious accusation that they said, look, we have to actually hold a hearing to hear this one. And they held it, and then they said, there's nothing here. This is completely baseless. But it gets better. Now we're to this week. And this week, after several motions back and forth and other things that have happened within this case, Mark Means files yet an addendum to his last request, and seeking that the DA, Mr. Wood, is somehow obstructing him in being able to offer and give a complete defense for Lori Vallow because of a hard drive. A hard drive that had been listed in the discovery that had evidence on it, phone calls and other records that were on this actual hard drive itself. Mr. Woods got it. He had it forensically examined. He had it all put down and backed up onto another device, and then he had a transcript made of everything that is actually on it. He had it mailed from the state of Idaho, not his office, but the state of Idaho forensics examiner mailed it back. Mr. Woods had the forensics examiner mail it back on the 19th. Had it mailed to Mr. Means on the 19th. On the 26th, he filed a motion saying that he was obstructing him and being able to give a complete defense to Lori, and wanted the state censured for, again, doing something that wasn't wrong. And then he goes off the rail with another series of requests. He says that the meeting room that every other attorney in the entire state has to put up with, speaking to your client with plexiglass between you and your client, and maybe you have to talk on a phone. Some places have holes drilled in the plastic itself, but right now they are using, a communication standard as an actual, home phone that you would put up to your home, to you, and the other person can hear, has to pick up the phone, and they can hear you as well. He says that this is an obstruction to his ability to communicate with his client, and that the room is inadequate. He is given a room that is 12 feet by 21 feet, and there are 2 stools in there on each side of the plexiglass. And he only has a small area to actually be able to communicate with his client. And he actually took photos with his own cell phone of him holding up pieces of paper to the plexiglass. And so his client on the other side can't actually read the actual document that he is talking about. And that he has to set his cell phone in his tablet or computer on the other seat next to him. He says this is inadequate. And because it's inadequate, and he can't effectively communicate with Lori Vallow, he wants Lori Vallow to be given a cell phone. Yes. Now, going back about the hard drive really quickly. There are multiple ways that he should have sought remedy in the situation if he really thought that the state was withholding this information from him and from his ability to defend Lori Vallow. The first one would have been pick up the phone and call the DA and say, hey, I still haven't gotten that hard drive. It's been 6 days, 7 days. What's going on? Do you have a tracking number for it? Or shipping information from the, what courier or service or whatever did the state use? You could have called him. He could have typed out an email and asked him that way. He could have sent him a text message on a cell phone. Any of these are acceptable and often used means of communication between individuals. It's not the first time that a phone has been used, and it's not the first time that somebody has sent an email or a text message. It's not new technology. The next remedy, or course of remedy, is he could have walked his happy little ass down to his car, gotten in his car, driven the 2.3 miles over to the DA's office, gotten out of his car, walked his happy little ass into the building itself, and asked Mr. Woods for the information. All of these are acceptable remedies and all legal and things that he should have done, and every other attorney would do it, and every other person who needed the information right then and there would probably have thought of. But not Mr. Means. No, not Mr. Means. Mr. Means filed a motion in court and said, those people are trying to get in the way of me defending my client. I want them censured. I want you to rule, Mr. Judge, that they're obstructing me in my ability to effectively defend my client. Wow. So wrong and so out of place. Why did he go that route? We don't know. But now back to the cell phone. It's against the rules in every county jail and every state jail and every state prison and every federal prison and every federal jail in the state of Idaho for an inmate to have a cell phone. It is against the rules. Now, that rule is set up by the Department of Corrections. It's not set up by the attorneys in court. Well, we would give you cell phones, but we decided in court today that you don't get one. But nor does he. Nobody gets a cell phone in court, and for obvious reasons. If somebody has a cell phone and they're able to communicate freely at any time with the outside world, they can do multiple things. I don't know, maybe set up a hit on somebody who's going to testify against them. Maybe talk to their friends on the outside to, this is when you should break me out of prison or the jail. Or maybe this is who you should harass, who's going to testify against me in court. They're multiple things. Maybe order a pizza. I don't know what the reasons are besides those, but there has to be multiple different reasons why they don't want inmates to have a cell phone. You can't just give them a cell phone and then use it to communicate, because what Mr. Means is asking is she be given a cell phone so she can communicate with him whenever he needs to communicate with her. So that means that she would have it with her at all times. And she would be able to communicate with Mr. Dumbbell, Chad himself. She'd be able to communicate instead of having to pick up the phone and call Mr. Woods, which she can do from a phone on the wall there at any time she needs to or he needs to. But he doesn't want it that way. He wants her to get a cell phone. So guess what? Guess what's going to not work again, Mr. Means? Your motion to get her a cell phone and the motion to have the state, punished for whatever grievance you may have because the United States Post Office is slow and you didn't give it even a week, not counting the weekends, because if you sent it any other methods besides priority mail, and maybe it wasn't, maybe it was, and you could also ask, maybe John Pryor has it, because they both share the same law office. Maybe it was shipped to John Pryor and Mr. Means, because they share the same offices to share on expenses. Or maybe one of the law clerks there has it, or one of the secretaries, or somebody else in the office maybe have gotten the package and set it on a shelf someplace. And maybe it's already there. We don't know. But is it really, the motion and the avenue for him to go through was to file in court that the state is obstructing him again? No. It's a long, crazy, crazy series of events. And I really wonder, and I still do wonder, if Mr. Means has the ability and the knowledge and the experience at all to be going forth with this trial as Lori Vallows' attorney. And it's going to be easy. The more crazy things that he does like this, the easier it's going to be for Mr. Wood to prosecute her and have her found guilty to the maximum, amount of the law, and for everything, from the misdemeanors and the felonies. If she is not going to get anybody who can really, fight for her and know what's going on. Yes, we all know Lori Vallow is guilty as hell. We know that. That's not even a question. But it's going to make it really easy for Mr. Woods. I bet he's sitting back right now just, licking his chops going, wow. I mean, what's next? Ask for a bail hearing because Lori didn't have the right shade of lipstick? We don't know at this point. But it's getting crazier and crazier as it goes along. Thank you for joining me today. You stay safe out there. Oh, that's the end of the video. I hope you enjoyed it. If you did, I would really appreciate it if you'd give this a thumbs up, and let YouTube and the algorithm know that you enjoyed this content. If you have only watched one video and this is it, well, thank you for stopping by. But I have a whole channel of over 500 videos for on YouTube right now. Why don't you go check one out? Links are down below. There's a next suggested video there. You can subscribe too. I wouldn't mind if you would do that.